Docket 41436, Supreme Court of Canada. The extenuating circumstances is that the judgment passed by Judge Central, it clearly looks as if the city of Toronto coerced with the judge to come to that judgment, that it was frivolous. But we know this case cannot be frivolous. Number one, we have the market research firm that stated that they were hired by the media to poll who the front runners were, and it was not the public they asked, it was the media. So the public did not determine who these 6 front runners were. That's one point. Now, second point, how could Judge Central ignore Mr. Clark being shoveled attacked off stage for walking on stage saying, "You will not fix the election"? The police were present. If Mr. Clark was performing an illegal act, the police would have been there, not a private security firm. And in fact, Mark Saunders, the Daily Bread said, choose not to participate. But they also say they only had room for 6 individuals, 6 candidates. But this proved that they did not, because when they attacked Mr. Clark and Mr. Logan Paul, who was kicked out, yet they did not replace Mark Saunders. If the debate wasn't rigged for a 6 specific individual, they would have replaced Mark Saunders with one of the other 96 other individuals. So clearly, this case is not frivolous because the facts and the evidence don't lie. Also, Mr. Clark and other candidates being blocked on email by the media. Right? The media does not choose the mayor. They do not choose the front runner. It's the people. And the people never had a choice. So clearly, Judge Central's decision to focus on a satire photo, and Judge Central, by saying, seems to be there to embarrass the mayor, shows that Judge Central was pro Olivia Chow in that decision, or he would have looked at the evidence of Mr. Clark, a candidate who we would contact the Daily Bread long before, and we will show that documentation. And Mr. Clark did not run on stage or rush the stage. He walked on stage and says, "I'm here. You will not rig the election." But yet they said, "Okay, Mr. Clark, now let's see. Let's have some of this participate." That is clear evidence that the judge and the city coerced. Clearly, the city had to coerce the judge for there to be a motion, and Mr. Clark was not notified. Mr. Clark was not stated that, oh, there's a motion. Mr. Clark is the applicant. Mr. Clark is not the respondent. I can understand the motion was filed by Mr. Clark, but this is a motion by the applicant. You don't, by the respondent, and you don't inform the applicant. You gave him 15 days to reply. And look how swift the judge replied. And yet, there was no record of it. Clearly, the city, in one way or another, coerced the judge, stating that maybe it's going to cost so much money for a new election. And we need a court to look at this case. And the court, if we add other judges, give a second opinion, determine whether it is frivolous or not. But clearly, Judge Central was coerced, and that evidence was not put forth because it would be clear that the judges would have realized that there's no way you can say this case is frivolous with the extensive media coverage of specifically 6 candidates, and a candidate refusing to join in the debate, but yet that candidate wasn't replaced. Clearly, this case must be heard. God's witness.